They had him handcuffed, dressed in an orange jumpsuit, sitting behind a defendant's table in a courtroom that smelled of mildew and broken promises. They had a file full of planted evidence, a compliant prosecutor, and 20 years of getting away with doing exactly this kind of thing. Detective Ray Hutchins leaned back in his chair, arms crossed, wearing the discreet smile of a man who had already written the ending. He had no idea, not the faintest hint, that the man sitting in those handcuffs had been waiting for this very moment for 3 years, and that the ending Ray Hutchins had written was about to be torn to shreds, burned and buried. The night of October 14th began, as most catastrophic nights do, in silence. Darnell Cooper was driving a black Audi A6 rented by the Riverside district of Harlow City, a mid-sized metropolis in Georgia that looked respectable from the freeway but rotten inside once you passed the welcome signs. He wore a navy wool coat, a silver watch left to him by his late father, and a calm expression that never changed, no matter what was happening around him. Those who knew Darnell well said his face was like still water. You couldn't guess the depths by looking at the surface. He stopped at a red light at the intersection of Calvert and 9th. A police car pulled up beside him. The light turned green. Darnell drove exactly 3 blocks before the patrol car's lights exploded behind him, red and blue flashing through the October fog like a warning of something ancient. He stopped. He placed both hands on the steering wheel, wide open. He kept his breathing even. He'd done it before. Every black man in America has done it before. The officer who approached his window was Detective First Class Ray Hutchins, though Darnell wouldn't learn the man's full name until 6 hours later. What he saw at first glance was a broad-shouldered white man, about 45 years old, his jaw clenched with that particular kind of arrogance that grows when authority goes unchecked for too long. Ray Hutchins had been with the Harlow City Police Department for 19 years. He had received 4 commendations, 2 formal complaints that vanished before they could be investigated, and an internal affairs report that had been sealed under circumstances no one wanted to discuss. Behind Ray, a second officer got out of the passenger side. It was Detective Scott Briggs, younger, maybe 32, with short red hair and eyes that darted around too much, the eyes of a man always calculating his options. Briggs had been Ray's partner for 6 years. Everyone in the department knew that wherever Ray went, Scott followed. And wherever Scott followed, things usually went badly for those who couldn't defend themselves. "License and registration," Ray said. "No, please. No, sir. No, good afternoon." Just those 3 words, short and definitive, as if he was already bored with the whole transaction. Darnell handed over both documents without a word. Ray studied them with the exaggerated slowness of a man who was acting out his authority rather than exercising it. "Get out of the vehicle." "Can I ask why I was pulled over?" Ray's eyes went flat. "Broken taillight." "Get out." The taillight wasn't broken. Darnell had checked the car when he picked it up from the rental agency that afternoon. He checked everything. He always checked everything. He got out anyway. What happened in the next 4 minutes happened quickly and with the practiced efficiency of men who had done it many times. Scott Briggs moved to the passenger side of the Audi while Ray kept Darnell standing by the driver's door. Then Ray said he was going to conduct a pat-down for the officer's safety. Darnell submitted. And during those 40 seconds, when Darnell's hands were on the roof and Ray's were moving around his sides, Scott Briggs reached into the rental car's glove compartment and placed something there. A small, vacuum-sealed bag containing what appeared to be about 40 grams of cocaine. When Ray walked around the car, he opened the passenger door, looked inside, and said, slowly and with theatrical surprise, "Wow, that's crazy." Darnell Cooper's expression didn't change. The still water didn't stir. He was arrested. He was handcuffed. His rights were read to him in a tone that suggested the officer reading them was finding the whole procedure tedious. He was put in the back of the patrol car, and as the car drove away, Ray Hutchins glanced in the rearview mirror at the man in the back seat and said to Briggs quietly, almost gleefully, "One down on the street." Briggs laughed, and Darnell Cooper, sitting in the back seat with his hands cuffed behind his back and his silver watch pinching his wrist, looked out at the fog-shrouded streets of Harlow City and thought, "Good. Now we're off." The Harlow City Police Department's holding facility smelled of equal parts bleach and despair. The fluorescent lights whirred at a frequency that seemed specifically designed to erode a person's sense of time. Darnell was processed at 11:47 p.m. They took his photograph, fingerprints, and confiscated his watch, phone, wallet, and coat. The admitting officer, a bored young man named Corporal Dennis Yates, entered everything into the system with the mechanical indifference of someone filling out a grocery order. While Dennis typed, Ray Hutchins stood at the counter, talking. He talked like men do when they've stopped fearing the consequences, confidently, chest out, filling the silence with the sound of his own certainty. 40 grams, Ray said, not addressing anyone in particular. That's intent to distribute. The prosecutor's going to love this. Clean arrest, clean evidence, no fuss. Briggs was leaning against the wall, looking at his phone. What's his story? Did he say anything? Not a word. He just stared at me the whole way like he was memorizing my face. Ray snorted. Let him look. No matter what he memorizes, it doesn't matter where he's going. Darnell was put in a holding cell at 12:15 a.m. The cell held 3 other men, a young guy, maybe 20, who was clearly terrified, an older, heavy-set man who was asleep on the bench and snoring, and a thin man with a tattoo on his neck who studied Darnell for a moment before nodding once and going back to what he was doing. Darnell sat on the bench, put his arms on his knees, and waited. He had been preparing for this night for 37 months. Let's be precise about who Darnell Cooper was, because the courtroom would eventually make that clear. But in that holding cell, in those pre-dawn hours, he was just a man in a cage, and the system around him operated exactly as it had been designed to operate when it encountered men who looked like him. Darnell had grown up in the Clifton Heights neighborhood of Atlanta. Not the wealthy part, not the part that travel magazines write about. He had grown up in a single-parent household with a mother who worked 2 jobs and a father who worked 3 until the third one sent him to an early grave. Darnell had been sharp from childhood, the kind of sharpness that teachers sometimes acknowledged and sometimes resented. He had earned a scholarship to Morehouse, then a full scholarship to Georgetown Law, where he graduated 3rd in his class. He had worked as a clerk for a federal judge in the 11th Circuit. He had spent 7 years as an assistant U.S. attorney, prosecuting organized crime and public corruption cases with a conviction rate that unsettled senior lawyers the way excellence sometimes does. 3 years ago, Darnell Cooper had been appointed to a position most people in the room that night would never have guessed existed: Special Research Advisor for the Civil Rights Division of the Justice Department's Office of Law Enforcement Accountability. His specific mandate, his very specific, highly classified mandate, was to build prosecutable federal cases against law enforcement agencies involved in systematically planting evidence, civil rights violations, and organized corruption. He had been investigating the Harlow City PD for 37 months. He had been investigating Ray Hutchins for 22 of those months. In the holding cell at 2 a.m., one of the other inmates, the terrified young man, asked Darnell what he was being accused of. Darnell looked at him. Planted evidence. The boy nodded slowly, as if it wasn't a surprising answer. Do you have a lawyer? I have access to one. Darnell said. "A public defender?" the boy asked. "Man, those guys are—" "No," Darnell said. "Not a public defender." He said nothing more than that. He sat in the whir of the fluorescent lights and waited. The Harlow City District Attorney's office was headed by a man named Gerald Thornton, a 58-year-old career politician who had been a district attorney for 11 years and had that kind of well-dressed confidence that comes from never having lost anything that mattered. Gerald was tall, silver-haired, and possessed a handshake so firm it bordered on aggression. He wasn't a stupid man, but he was a man who had made peace with the machinery of his office, including the parts of the machinery that bent. Gerald's lead prosecutor on drug cases was a woman named Linda Forsythe, 41 years old, efficient, razor-sharp, with a reputation for high conviction rates that she protected with the ferocity of someone who understood exactly how much those numbers meant to her career. Linda wasn't corrupt in the way Ray Hutchkins was. She was corrupt in a more subtle, more common way. She believed what the police told her, asked few questions that might complicate the answers, and defined justice largely as winning. When Linda received Darnell Cooper's file at 7:30 the morning after the arrest, she reviewed it in 12 minutes. 40 grams of cocaine found in the vehicle, clean chain of custody documentation. Ray and Scott were always meticulous with their paperwork, another reason they'd never been caught. The defendant had no prior record, something Linda briefly noted as unusual but not disqualifying. She set bail at an amount that would be difficult for most people to reach and scheduled the arraignment for 3 days later. No one at the prosecutor's office ran Darnell Cooper's name through federal databases. No one called his employer. No one asked why a man with no criminal record was driving through the Riverside district at 11 p.m. with 40 grams of cocaine in his glove compartment. No one asked why the car rental agreement in his name showed no prior problems with the vehicle. They saw what they expected to see and moved on with the efficiency of a system that had long ago learned that asking certain questions was bad for productivity. Meanwhile, Darnell Cooper made a phone call from a holding cell phone at 8 a.m. He dialed a number in Washington, D.C. The phone rang twice. A woman answered. Her name was Sandra Okafor, and she was the assistant director of the Civil Rights Division at the Department of Justice. Her voice, upon hearing Darnell's, shifted from professional to more alert. "Tell me," she said. "It happened," Darnell said. "Hutchkins and Briggs exactly as we expected, as documented in the previous 7 cases." A pause. "Are you okay?" "Completely. I need you to let it run. Don't make any calls to the prosecutor's office. Don't send anyone. Let it go to arraignment, and let it go to trial if it goes there." Another pause. "Longer this time." "Darnell, that could be—" "I know what it could be. Let it go. I need them to be comfortable." Sandra Okafor was silent for 3 seconds. "Do you have everything you need?" "I have everything I've had for 3 years. I just need a courtroom." She hung up. She sat back down on the bench in the holding cell. She clasped her hands together. She waited. 3 days later, Darnell Cooper appeared in Courtroom 7 of the Harlow County Superior Court for his arraignment. He wore the clothes he had been arrested in, slightly wrinkled, and had declined the assigned public defender, requesting instead to represent himself pro se, which prompted the clerk processing the paperwork to raise an eyebrow but say nothing. The presiding judge at the arraignment was the Honorable Patricia Weston, 62 years old, 20 years on the bench, known for her impatience with theatrical lawyers and her meticulous adherence to procedure. She had seen it all, or thought she had. Linda Forsythe sat at the prosecution table, looking impeccable and prepared. Ray Hutchkins sat in the gallery behind her, still sporting that low-key smile. Scott Briggs stood beside her, staring at his phone until a bailiff told him to put it away. Darnell sat alone at the defense table. Judge Weston peered at him over her glasses. "Mr. Cooper, you have chosen to represent yourself in this proceeding?" "Yes, Your Honor." "Do you understand that you have a right to counsel?" "I do." "And are you waiving that right?" "For today's proceeding, yes. I will obtain representation before the trial." Weston looked at him a moment longer than usual. There was something about the way the defendant stood. Not defiant, not nervous, just composed in a way that didn't quite fit the courtroom's expectations. She made a quick mental note and moved on. The charges were read. Possession of a controlled substance with intent to distribute. Darnell pleaded not guilty. Linda requested the bail she had already set. Darnell didn't contest it, which was odd because bail was $75,000. Most defendants at this point would be desperate, calling relatives, calculating how much a bail bondsman would cost, figuring out how long they could survive in a cage. Darnell simply said, "I'll put the full amount in at the end of the day, Your Honor." Linda Forsythe turned to look at him. Judge Weston looked at him. Even the court stenographer, a middle-aged woman named Gloria Sims, who had worked at that court for 15 years, looked up from her stenographer. Ray Hutchkins' smile faded exactly 1 degree. Darnell Cooper paid $75,000 in cash for bail at 4 in the afternoon and walked out of the Harlow County Correctional Facility into the dim October sunlight. He paused on the sidewalk for a moment, smoothed down his coat, and dialed a number on his personal cell phone. A different phone than the one confiscated during the search because Darnell Cooper always carried 2 phones. "I'm out," he said. "Start preparing the filings. We're about 3 weeks from the end." What happened in the 2 weeks between Darnell Cooper's arraignment and his trial was invisible to everyone in Harlow City. It was happening in Washington, D.C., in Munich, in federal offices with sealed door protocols, and in a rented conference room at an Atlanta law firm that had been scanned for listening devices twice before the first hearing. The lawyer Darnell had secured, the one he had told Judge Weston he would find, was a man named Theodore Ashe. Ted Ashe was 67 years old, semi-retired, and one of the most decorated civil trial lawyers in the southeastern United States. He had argued 4 cases before the Supreme Court. He had won 3 of them. He had a reputation for surgical cross-examination, which former opponents consistently described with a kind of traumatized reverence as being autopsied while still alive. Ted Ashe had also been Darnell's mentor at Georgetown Law 19 years earlier. When Ted sat across from Darnell in that lecture hall in Atlanta and opened the file Darnell slid across the table, he was silent for a long time, not because he was surprised, but because he was reading it carefully, like a surgeon reading a scan before picking up a scalpel. The file contained 37 months' worth of documentation. It was organized into 7 sections. The first section covered the history of Ray Hutchkins and Scott Briggs, their 19 and 6 years of service respectively, their commendation records, and their disciplinary histories, including the 2 missing complaints and the sealed internal affairs file. The second section contained surveillance data, vehicle movements, warrant-obtained phone records, and time-stamped photographs. The third section contained the sworn testimony of 11 former defendants, black men and 1 black woman, who had been arrested by Hutchkins and Briggs on drug charges that Darnell's investigation had identified as almost certainly involving planted evidence. 4 of those defendants had already served part of their prison sentences. 2 remained incarcerated. Section 4 was a forensic analysis of the chain of custody of drug evidence in 8 cases, including Darnell's, conducted by a federal laboratory in Quantico. The analysis identified a specific batch marker in the cocaine used in 3 different cases, separated by 18 months, meaning that the drugs planted in the vehicles of 3 different defendants came from the same source. Section 5 was financial. Ray Hutchkins had a savings account that did not match his salary. a lakeside house in Tennessee, was purchased in his wife's maiden name. His daughter's tuition at a private university was paid in full through an LLC that forensic accountants had traced through 4 layers of corporate paperwork to a mid-level drug dealer named Calvin Spear, who operated in the Riverside district of Harlow City. Section 6 was the operational record of Darnell's own investigation, including the night of October 14th, which had been documented beforehand. The route he had driven was deliberately selected. The rental car was deliberately chosen and rented in his own name to create a clean paper trail. The taillight was inspected and verified as functional before he left. The body camera he was wearing, disguised as a pin, had recorded Ray Hutchkins approaching the entire traffic stop and the 4-minute window in which Scott Briggs had been alone on the passenger side of the vehicle. Section 7 consisted of the federal charges already drafted, reviewed, and approved by 2 senior federal prosecutors, awaiting only the conclusion of the state trial to ensure all evidence had been entered into the public record under oath before the federal gavel fell. Ted Ash closed the case. He stared at Darnell for a long moment. "You let yourself be arrested?" "Yes." "You let yourself be put in a cage for 41 hours? You could have identified yourself the moment they approached the car." "I know. Why didn't you?" Darnell was silent for a moment. He looked at his hands on the table. "Because 11 people before me didn't have the choice I had. They couldn't identify themselves as federal officers and make the problem disappear. They just went to jail. So I needed to fully understand personally in my own body what they experienced, and I needed a courtroom where everything these men have done was recorded under oath in public, not in a sealed federal filing, in public, where everyone in this city can see it." Ted Ash looked at it for another long moment. Then he reopened the file. "Tell me when you want to start," he said. The state of Georgia's trial against Darnell Cooper began on a Tuesday morning in November, 3.5 weeks after the arrest. Courtroom 12 of the Harlow County Superior Court had a gallery that could hold about 90 spectators. On the day the trial began, 87 of those seats were occupied. This was unusual for a drug possession case. Word had gotten out, not about who Darnell really was, because that information was still sealed, but about the fact that this defendant had paid $75,000 in cash bail without flinching, that he had walked into the arraignment without a lawyer and seemed completely unfazed by it, and that the lawyer now sitting next to him was Theodore Ash, whose face had been on the cover of the Georgia Legal Review 3 times. Ray Hutchkins was back in the gallery. Suit and tie today. Less smiling, more vigilance. He was watching Darnell and Ted Ash with the quiet attention of a man who had begun to wonder, just barely, if something was slightly amiss. Scott Briggs wasn't in the gallery. He had called in sick that morning, telling the duty sergeant it was a stomach virus. The duty sergeant hadn't asked any follow-up questions. Judge Weston presided. Linda Forsythe prosecuted. Ted Ash defended. The first day was routine. Linda presented the prosecution's case with her usual precision: the arrest, the discovery, the chain of custody, the lab analysis confirming cocaine. She called Corporal Dennis Yates to testify about the booking procedure. She called a forensic chemist named Dr. Paul Renier from the state crime lab, who confirmed the substance was cocaine hydrochloride, approximately 41.3 grams, consistent with an intent to distribute. Ted Ash's cross-examination of Yates was brief, almost tedious. His cross-examination of Dr. Renier was precise and technical, questioning the batch analysis methodology in a way that confused Linda and seemed to bore the jury, though 2 jurors were watching more attentively than they had all day. At the end of the first day, as the courtroom was emptying, Ray Hutchkins found Linda Forsythe in the hallway. "What's Ash doing?" Ray asked. "His job," Linda said with the mild irritation of someone who doesn't like being questioned by witnesses. Calm down. Don't get paranoid. I'm not paranoid. You're paranoid. You're going to take the stand tomorrow. Tell the same story you've told 8 times before. It always works. Rye nodded. He walked toward the elevator, but by the time the doors closed, the smile was gone. Day 2. Ray Hutchkins took the stand in the morning. Linda walked him through the arrest with practiced fluency, the traffic stop, the taillight. He was specific and confident about the taillight, the superficial search, the discovery of the drugs. He was fine on the stand. 19 years of experience, 4 commendations, the easy authority of a man used to being believed. The jury watched him the way juries watch police officers, with a base of distrust that prosecutors understand and count on. Then Ted Ashe stood up. He rose slowly, the way elderly people rise when they've conserved their energy for something important. He walked to the podium. He placed a single sheet of paper down. He looked at Ray Hutchkins for a moment without speaking, the way expert interrogators sometimes do, letting the witness wonder, letting the courtroom's attention sharpen. Detective Hutchkins, Ted said, you testified that you observed a broken taillight on my client's vehicle at approximately 11:42 p.m. on October 14th. That's correct. And that broken taillight was the basis for the traffic stop? Yes. Ted took the sheet of paper. I'm going to introduce the defense's Exhibit A, a certified maintenance and inspection record from Premier Auto Rentals in Harlow City, dated October 14th at 3:17 p.m., approximately 8.5 hours before the stop, confirming that the vehicle rented by my client was inspected and that all external lights were in perfect working order. He handed the evidence to the clerk. Linda was already standing. Objection. Basis. The evidence includes the signature of Premier Auto Rentals certified mechanic Thomas Greer and an affidavit. Basis established, Your Honor. Weston looked at the document and dismissed the objection. Ted turned to Ray. In light of this inspection log, can you explain why the taillight was broken? Ray's jaw tightened almost imperceptibly. Headlights can break between an inspection and an encounter. It happens all the time. 8.5 hours. Yeah, on a parked rental car. It happens. Ted nodded slowly. Come in, he said, lowering the paper. Detective Hutchkins, during the stop, you conducted a pat-down search of my client. Is that correct? For the officer's safety. Yes. And during that pat-down search, your partner, Detective Briggs, was positioned on the passenger side of the vehicle. He was securing the perimeter. He was alone on the passenger side of a vehicle stopped for approximately 4 minutes. He was doing his job. Ted reached down and picked up a tablet. Evidence for Charge B from the defense. Your Honor, I'd like to show a video recording. Linda stood up again. Objection! The defense has not previously disclosed this. This was revealed in the list of evidence submitted to the court at 9 o'clock this morning. Evidence B is described as an audiovisual recording of the traffic stop. The prosecution received that submission. Weston looked at Linda. Counsel, did you receive the list of evidence? Linda's composure flickered for the first time. I received it, Your Honor, but I haven't. The evidence is admissible. Proceed, Mr. Ashe. The court projection screen lit up. The images were clear. The lapel pin cameras, it turned out, captured remarkably good video. The angle was from Darnell's own chest, pointing slightly down and to the right toward the passenger window of the Audi. The timestamp in the corner read 11:44 and 8 seconds p.m. and lasted 4 minutes and 12 seconds. In the footage, Scott Briggs could be seen moving around the passenger side of the vehicle. At 2 minutes and 17 seconds, Briggs leaned toward the passenger window. His hand moved to the glove compartment. He opened it. His hand went in. His hand came out. The glove compartment closed. At 2 minutes and 31 seconds, Ray Hutchins walked to the passenger door and opened it. He leaned over. He stood up, his face turned partially toward the dash cam, which he hadn't known was there. He wore an expression that tried very hard to look surprised. The courtroom was completely silent. Somewhere in the gallery, a woman inhaled sharply. Ray Hutchins, on the bench, had turned as red as old paper. "Detective Hutchins," said Ted Ashe, his voice completely, almost eerily calm. "Can you identify the man placing an object in my client's glove compartment?" Ray said nothing. "For the record, Detective, is that your partner, Scott Briggs, at 11:46:25 p.m.? The courtroom still held its breath. "I want a lawyer," said Ray Hutchins. The courtroom erupted. Judge Patricia Weston needed to bang her gavel 3 times before the noise in courtroom 12 subsided to a level where she could speak and be heard. When he finally did, he looked at Linda Forsythe with an expression that contained a multitude of emotions: confusion, professional discomfort, and something rapidly turning into alarm. "Counsel," he said to Linda, "do you want a recess?" Linda Forsythe was standing by her desk, staring at the frozen image on the projection screen. Scott Briggs's hand was perched on the edge of the glove compartment, his expression that of someone who has just realized the building they're in isn't the building they thought it was. "Your Honor," she said, her voice remarkably steady for someone who seemed to be experiencing the slow-motion collapse of her professional assumptions. "Yes, the prosecution requests a 30-minute recess." 30 minutes, Weston said. He struck his gavel. "This court is in recess." He rose, and before walking to his chambers, he glanced at Darnell Cooper for the second time since this trial began. A longer look than before, the water still, the face composed. Something in his expression shifted, though he said nothing. The gallery emptied into the controlled chaos of 100 people trying to make phone calls simultaneously. Ted Ashe leaned toward Darnell and said very quietly, "Ready?" "Almost," Darnell said. During the recess, 2 things happened simultaneously. In the courthouse hallway, Ray Hutchins called Scott Briggs. The call went to voicemail. He called again. Voicemail. He called a 3rd time, and this time a different voice answered, a voice Ray didn't recognize. Calm and professional, he said, "This is Special Agent Kevin Drummond with the FBI Civil Rights Unit. Detective Briggs is in federal custody. Are you Detective Hutchins?" Ray hung up. He stood in the courthouse hallway, phone in hand, and for the first time in a long time, Raymond Lee Hutchins felt afraid. In Gerald Thornton's office on the 4th floor, Linda Forsythe was on the phone with the Attorney General himself, speaking in short, low tones, like someone delivering news she was still processing. Gerald Thornton, meanwhile, sat very still in his large leather armchair, asking short, pointed questions and receiving answers that made his silver hair seem to have turned a little grayer. When the court resumed, Linda Forsythe stood and said something she had probably never said in 11 years of prosecution. "Your Honor, the prosecution requests the dismissal of all charges against the defendant." Judge Weston looked at her for a moment. "On what grounds?" "Tambling of evidence. The integrity of the arrest has been compromised." "The motion to dismiss is—" Weston paused. She looked at Ted Ashe. "Any objection, Mr. Ashe?" "No objection to dismissal, Your Honor." Ted paused. "However, the defense has an additional motion." "I'll hear it." Ted Ashe placed both hands on the podium. "Your Honor, we request that the court admit as evidence the complete investigative file compiled over the past 37 months by my client." He paused. And that was the pause everyone in that room would remember for the rest of their lives. Special Investigative Counsel Darnell A. Cooper, Civil Rights Division, United States Department of Justice. The silence that followed was not ordinary silence. It was the silence of a room where something structural had just shifted, like the moment after an earthquake, when everything has stopped moving, but nothing is quite the same. Judge Weston slowly removed her reading glasses. She glanced at Darnell Cooper. "The defendant is a federal officer." Darnell stood. He had been waiting for this moment for 37 months, and the expression on his face was not triumphant. It was quieter than that, more serene. The expression of someone who has been carrying something for a long time and has finally been allowed to let it go. "Special Investigating Counsel." "Yes, Your Honor." "My identification and credentials are in the defense's evidence C, along with a letter from the Assistant Director of the Civil Rights Division of the Department of Justice confirming my appointment and the mandate of my investigation." He reached into his jacket pocket and pulled out the documents. They were passed to the clerk. They were given to Judge Weston. He read them silently as the entire courtroom watched his face change. Then he placed the documents on his bench and looked across the gallery and saw Ray Hutchkins sitting 4 rows back, his hands on his knees, his face completely devoid of his usual smile. And he said, in a perfectly controlled voice, yet one that held something as hard as granite beneath it, "Marshal, arrest Detective Hutchkins, please." The next 72 hours passed with the speed of things that have been brewing for a long time, and finally have no more resistance. Ray Hutchkins was arrested in courtroom 12. He was handcuffed in the same courtroom where he had expected to see Darnell Cooper sentenced. He was escorted past the gallery, past the 87 spectators who had come to an ordinary drug trial and were leaving with something they would talk about for the rest of their lives, in a silence that was more devastating than any noise could have been. Scott Briggs, as Rye had already discovered, had been arrested by Special Agent Kevin Drummond's team at 9:45 a.m. before the court had resumed at his apartment complex on the south side of Harlow City. Scott had answered the door in a bathrobe, believing him to be the building superintendent. He wasn't. Apparently, he hadn't said a word during the first 40 minutes of federal custody, and then he'd said quite a lot. The Attorney General's office began its internal review at 2 p.m. that same day. Gerald Thornton issued a statement at 4:30 p.m. announcing that his office was fully cooperating with federal investigators and conducting a thorough review of all drug cases prosecuted in the past decade that originated with the arrests of Hutchkins and Briggs. The statement made no mention that Gerald had been privately told by an FBI liaison that the review was not optional and that his own office's handling of potentially tainted evidence was also being examined. Linda Forsythe was not named in any of the initial statements. But Linda Forsythe, sitting in her office that night after everyone had left, looked at the case files she now saw differently. Files she had taken for granted, files she had run through the machinery without asking the questions she should have asked. Linda Forsythe was doing her own accounting, and the accounting was not in her favor. Later, she would cooperate with federal investigators and testify against Hutchkins and Briggs. Later still, she would acknowledge in a sworn deposition that she had pursued convictions with a willfully negligent curiosity about their basis. She would lose her position in the Attorney General's office. She would not be criminally charged. This was the subject of considerable debate. In the Riverside district of Harlow City, a man named Calvin Spear, a mid-level drug dealer connected to Ray Hutchkins' Lake House funding, was arrested at 7 p.m. by a joint FBI-DEA team at a warehouse on Porter Industrial Road. He had been cooperating with federal investigators under an offer agreement for 14 months. The cooperation began when Darnell Cooper's investigation identified him and offered him a deal. Full disclosure in exchange for a reduced sentence. Calvin Spear, a pragmatic man, accepted the offer. It was one of the evidentiary bases of the financial section of Darnell's indictment. By the end of the third day, the tally of arrests directly connected to Darnell Cooper's investigation had risen to Ray Hutchkins, Scott Briggs, and 4 other officers whose names had surfaced through Briggs's cooperation and Calvin Spear's testimony. A 7th arrest came a week later. A police captain named Arthur Moody, who for years had been the administrative figurehead that allowed Hutchkins' operation to function without interference from internal affairs. It was Arthur Moody who had sealed the original internal affairs file on Hutchkins. It was Arthur Moody whose retirement account contained approximately $340,000 in unexplained deposits. It was Arthur Moody who, upon being arrested at his home in a gated community in the northwest suburbs of Harlow City, reportedly sat on his front porch steps and wept. The case that Darnell Cooper had built, 37 months, 11 previously identified victims, hundreds of pages of documentation, the financial trail, forensic analysis, body camera footage, was presented in its entirety to the United States District Court for the Northern District of Georgia. The federal charges against Hutchkins alone totaled 23 counts, including civil rights violations under Section 1983 of Title 42 of the United States Code, tampering with evidence conspiracy, facilitating drug distribution, and wire fraud. The 11 defendants whose cases were identified as potentially tainted, including 4 who had served prison sentences and 2 who were still incarcerated, had their cases referred for immediate review by the Georgia Innocence Project and a special federal review panel. Within 6 weeks of Darnell's trial, 2 of the incarcerated men were released pending full reviews of their cases. Their names, which deserved to be clearly spoken, were Devin Washington, 34, who had served 18 months of a 4-year sentence, and Clarence Tibbs, 49, who had served 27 months of a 5-year sentence. Devin Washington's mother, a woman named Rosa Washington, gave a brief statement outside the correctional facility the day her son was released. She said only, "I never stopped believing he was telling the truth." Then she hugged her son in the November air and said nothing more for a long time. Ray Hutchkins' federal trial began 7 months after his arrest and lasted 3 weeks. Ted Ashe was not the lead attorney in that trial. Federal prosecutors don't usually work with defense attorneys in that role, but he was there, sitting in the gallery, watching with the patient attention of a man who had already done his part. Darnell Cooper testified on the 4th day. He testified for 6 hours in 2 sessions, calm, precise, thorough, laying out the architecture of his 37-month investigation with the methodical thoroughness of someone who had spent his career figuring out how to make juries understand complicated things. Ray Hutchkins' defense team worked hard. They argued the decoy, that Darnell had fabricated a situation to ensnare their client. The argument didn't hold up against the video evidence, financial records, forensic batch analysis linking 3 separate drug plant cases, and the cooperating testimony of Scott Briggs, which was detailed, specific, and devastating in the way that the testimony of a co-conspirator who has come to terms with his fate tends to be. Ray Hutchkins was found guilty on 19 of the 23 counts. The 4 acquittals were on charges where the chain of evidence had a technical procedural problem that his lawyers had successfully exploited. The jury deliberated for 11 hours. When the verdict was read, Ray Hutchkins stood at the defense table, his face completely still, not composed like Darnell's, but empty, the expression of a man from whom something fundamental has been taken. He had spent 19 years protected by the weight of institutional authority, by the predictability of a system that treated the testimony of certain men as gold and that of others as suspect. For 19 years the machine had worked, and now the machine was looking at him. He was sentenced to 22 years in federal prison. Scott Briggs, who had cooperated and testified, received a reduced sentence of 9 years. He would be eligible for parole after serving 60% of his sentence. His red hair had begun to turn gray during the months of proceedings. Arthur Moody, the captain who had silenced internal affairs complaints, was sentenced to 8 years. Gerald Thornton was not charged, but he was not re-elected either. He announced 3 months before the election that he would not seek a third term. The statement cited a desire to spend more time with his family. No one who read it believed that was the reason, presumably including Gerald Thornton. In the sentencing statement for Ray Hutchins, the federal judge, the Honorable Reginald Flowers of the United States District Court for the Northern District of Georgia, said something that was widely quoted and reprinted in the following weeks. He said the defendant spent 19 years using the authority of his badge to treat certain citizens as targets rather than as people deserving of protection. He systematically relied on the assumption that those targets would lack the resources, credibility, or power to hold him accountable. In that assumption, he was catastrophically wrong, and the weight of that error will be measured in the years he will now spend in federal prison, years that bear no relation to the years Devin Washington and Clarence Tibbs and 9 other innocent people lost. Ray Hutchins was escorted from the courtroom by federal marshals. His wife, sitting in the gallery, did not look up from her lap. His daughter, who had been in the courtroom every day, got up and left before the marshals reached the door. She didn't look back. In the months after the trial, several things happened that didn't make the headlines but mattered nonetheless. Devin Washington enrolled in a community college in Atlanta studying business administration. He was 34 years old and starting over with the particular determination of someone who understands exactly where he's starting again. A non-profit organization connected to the Georgia Innocence Project provided partial tuition support. Devin also filed a civil lawsuit against the city of Harlow and the Harlow Police Department, represented pro bono by a civil rights firm in Atlanta. The lawsuit was settled 18 months later for $1.4 million. Devin's attorney issued a statement. Devin made no public statement on the matter. He was known to be a private person. Clarence Tibbs was 50 years old at the time of his full exoneration. Before his arrest, he worked as an electrician. After his release, he returned to his trade. His employer, a modest electrical installation company in Harlow City, run by a man named Pete Holloway, kept his position open because he never believed the conviction would happen. Later, Pete Holloway told a reporter from the Atlanta Journal-Constitution that he had rehired Clarence the same week the exoneration came in, and that Clarence showed up Monday morning and worked the entire day without saying a word about it. That's Clarence for you, according to Pete. Rosa Washington, Devin's mother, became a central figure in a Harlow City community organization called the Alliance for Police Justice, which existed before the Hutchins case but experienced significant growth after the events. She gave interviews and attended city council meetings. According to everyone who knew her, she was a formidable person. Darnell Cooper continued her work in the Civil Rights Division of the Department of Justice. The Harlow City case became a model, studied, analyzed, and referenced in federal training materials as an example of how to document and prosecute the systematic planting of evidence. Darnell gave an interview to the Washington Post, conducted by a journalist named Patricia Sue, in which she was asked how she had endured 41 hours in a holding cell, knowing who she was and what she knew. His response, which the newspaper featured as a quote, was, "I endured it because 11 people before me suffered it without the option to end it when they wanted. The least I could do was understand what they went through. The most I could do was make sure it served a purpose." He declined all subsequent interview requests. The body camera footage, the 4-minute clip in which Scott Briggs planted the evidence, was viewed 47 million times across various platforms during the first week of its public release. A legal commentator named Harold Riggs, on a nationally televised program, called it the most momentous body camera recording in the history of police conduct cases in the United States. That may have been an exaggeration, but it's also possible it wasn't. The Harlow City Police Department was subjected to a federal consent decree that mandated independent oversight, required body camera policies, and a complete restructuring of its internal affairs division. Its implementation was slow, contested at every stage by various institutional interests, and imperfect. However, according to most accounts from those who observed it closely, it was more than had ever been achieved before. In the spring after the trial, Darnell Cooper returned to Harlow City for the first time since the verdict. He arrived quietly, without warning. He toured the Riverside district, this time not in a rented Audi, but in his own vehicle, a gray Ford Explorer with 80,000 miles and a crack in the passenger side sun visor. He drove along Calvert Street, past the intersection with 9th, and paused for a moment at the red light. He remained there for a full cycle of lights. Red, green, red, and then he continued on his way. What he thought during those 2 minutes he never said. Perhaps there was nothing to say about it. Some disillusionments are private, some justices are internal, the kind you carry within you, rather than proclaim from a podium. He left the Riverside district and took the freeway, and the fog-shrouded streets of Harlow City disappeared in his rearview mirror, and he headed home. There is something important to say about this story that isn't contained in the verdicts or the headlines or the 47 million views of a 4-minute video. 11 people, 11 real, specific, breathing human beings had been arrested by Ray Hutchins and Scott Briggs and confined to cells and processed through a system that treated their denials of innocence as noise and their convictions as metrics. Devon Washington lost 18 months. Clarence Tibbs lost 27. The other 9 lost varying amounts of years of probation, received criminal records, were unable to obtain jobs, were unable to afford housing, and experienced family structures that were disrupted by the absence of legal recourse, a situation that cannot be reversed even when a court document states it should. A federal review panel ultimately determined that the financial and professional damage inflicted on the 11 identified victims totaled more than $8 million in lost wages, legal costs, incarceration costs, and subsequent economic effects. This figure doesn't include the incalculable, the burden of not being believed, the erosion of faith in the institutions that were supposed to protect you, the particular exhaustion of being the kind of person the system treats as a target. Ray Hutchins, during his 22 years in federal prison, had time to reflect on what he had done. Whether he used that time for genuine reflection or to construct narratives that presented him as a victim of his own story is a question no one outside his cell can answer. People who knew him said he had always been good at constructing such narratives. They said he possessed the particular talent of a man who has become completely and almost sincerely convinced that his version of events is the true one. Whether 22 years is enough to dismantle that kind of self-deception, no one knows. Scott Briggs, serving a 9-year sentence with the possibility of parole after 5.5 years, reportedly requested a meeting with Devon Washington's attorney from the federal facility in Tennessee, where he was incarcerated. The request was relayed. Devon Washington's attorney forwarded it to Devon. Devon's reply was brief: "Not yet." Not yet is not never, nor is it forgiveness, and no one in their right mind would ask Devon Washington to move any faster towards something he will arrive at on his own terms, or not at all. Linda Forsythe went into private practice, handling real estate contracts and estate planning. She wasn't the villain of this story in the simple, straightforward sense. She was something more unsettling than a villain. She was someone who had every opportunity to see what was right in front of her and chose, consistently and professionally, not to look. Her cooperation with federal investigators was genuine in that she answered every question fully and truthfully, once the alternative was no longer viable, whether that was considered moral redemption or simply pragmatic self-preservation was a question she presumably spent her nights pondering. Gerald Thornton accepted a position at a private law firm that handled corporate compliance. He did not grant interviews. Arthur Moody was in a federal correctional facility in Florida. He was 61 years old. According to prison staff who spoke anonymously to a journalist writing a follow-up story, 14 months after his sentencing, he had become a quiet presence in the facility. He was not a troublemaker, not a leader, just a man grappling with the weight of what he had allowed. He had requested access to the mental health counseling program and had been granted it. The lakeside home in Tennessee that Ray Hutchkins had purchased in his wife's maiden name, the one whose existence was a key piece of evidence in Darnell's financial investigation, was liquidated as part of the asset forfeiture proceedings. The proceeds went in part to a restitution fund for the identified victims. Devin Washington received a check. Clarence Tibbs received a check. So did the other 9. The checks were, by the standards of what had been taken from them. Scarce money always is in these situations. The law does what it can, which is better than nothing and worse than enough. This story happened because one man refused to give up on the truth. For 37 months, Darnell Cooper could have filed his report from a safe distance. He could have built the case without putting himself in a jail cell. He chose otherwise. He chose to understand with his body, not just his mind, what Devin Washington, Clarence Tibbs, and 9 others had experienced. And in doing so, he built something that no institutional inertia could ignore. Ray Hutchkins sat in that courtroom believing he had already won. He had won 19 times before by his victims' count. 20. He had every reason to believe he would win again. He forgot one thing, that the man sitting in those handcuffs had been building the case against him for longer than he could have imagined. Justice is slow. It is imperfect. It doesn't heal everything it touches. But when it arrives, when it undeniably arrives, it comes with a weight that no ironic smile can bear. If this story has touched you, if it has made you feel the importance of unseen work, if it has reminded you that ordinary and extraordinary people fight these battles every day, then do something about it. Like it. Share it with someone who needs to hear it. Subscribe so you don't miss the next story we tell, because stories worth telling deserve an audience, and that audience is you.